Good evening, gentlemen. I'm sure we all had quite a lovely and blissful day. You're welcome to tonight's online session. I'm still your host, O.O. Stevens. And tonight we are going to be looking at pre-trial and trial proceedings in civil litigation. Pre-trial and trial proceedings in civil litigations. And in this topic, we are going to be looking at some of the steps to be taken by parties after filing of pleadings but before trial are commenced. So after the pleadings have been filed by parties, there are some other steps that they probably may take before the full trial would commence. And some of those steps are, we are going to outline them, then in the long run we will now briefly discuss each of them. We have proceedings in lieu of demurrer. Demurrer is spelled D-E-M-U-R-R-E-R, demurrer. So proceedings in lieu of demurrer. I have told us that in lieu means instead. In lieu means instead. So in lieu of demurrer. So just like proceedings instead of demurrer. So we're going to be looking at that and appreciating the principle of law under it. We're also going to be looking at striking out of pleadings. Striking out of pleadings can also be some of the steps that can be taken after filing of pleadings. So the court may strike out pleadings even when such has not gone to trial. We also look at consolidation and deconsolidation of actions. Consolidation and deconsolidation of action. We're also going to be looking at interrogatories, discoveries, and inspection of documents. We'll also be looking at notice to admit. We'll also be looking at settlement of issues. We'll also be looking at case management conference. I'll also be looking at withdrawal or discontinuance of action. Remember, our interest in this particular topic are the steps that can likely be taken before full trial, but after filing of pleadings. So it's either the parties will take the step or the court can take the step. In Lagos, some of these issues are taken before trial, while in Abuja, these proceedings may be taken at any time, even before judgment is given. And it is pertinent to note that some of these applications may terminate the proceedings before trial, such as notice to admit, striking out of proceedings, withdrawal or discontinuance of action. So just as we said that these are the steps taken before trial, but there are some of these steps that can on themselves bring the particular matter to an end, even without going to full-blown trial. And we have outlined that assuming the step taken is notice to quit, then such can actually bring that particular matter to an end. And assuming it is withdrawal, maybe either of the parties have withdrawn the action, then such can also bring the matter to an end. And even when the pleadings were struck out, then such can bring the matter to an end even without going to full-blown trial. All right, let us look at the concept of proceedings in lieu of demurrer. I am going to explanatorily discuss this. Now, if any party or if the defendant wishes to object to the jurisdiction of the court after having been served with the statement of claim or with the documents from the claimant, such a defendant can, without entering appearance, without filing his pleadings, without filing statement of defense, he will file another separate document to the court. And that separate document is filing to the court would be to the effect that he is raising an objection to the jurisdiction of the court. So meaning he is not submitting himself to the court's jurisdiction. And that particular objection that he is raising is known as demurrer. Such a particular objection that he is raising is known as demurrer. Now, presently, the old rule is no longer in vogue. What is now obtained presently now is that even if the defendant wishes to raise any objection, he should still file his statement of defense, but he can raise the objection that he has in that statement of defense. So he can still enter his appearance, but he can raise his objection when he has filed his statement of defense. So that means now that instead of filing that separate document called demurrer, he can now file his statement of defense, and he will now raise that particular objection in statement of defense. That is proceeding instead of demurrer. That is proceeding instead of, that is where we get the name proceeding in lieu of demurrer. That is proceeding instead of demurrer. So that is just the brief explanation, because most often than not, if you read this up in a book, the books tend to confuse. You don't really tend to appreciate what the book is saying, except there is an explanation to it. So this is just what it means. It means that if you have any objection, file your pleadings, but raise the objection in your pleading. Don't waste the time of the court by filing a separate document where you are objecting. Then after the court might have finished determining it, then that is when you can now come back now and file your statement of defense. No. So the court said file your statement of defense and raise the objection in it, so that the court will consider both the objection and statement of defense at the same time. So that in an event whereby maybe your objection does not hold water or your objection is not valid, then the time of the court will not be wasted to give you another number of days for you to file your statement of defense. So that is the implication of that. Now let us look at the concept of striking out of pleadings. When we say that pleadings have been struck off, pleadings can be struck out by the court in any of the following circumstances. Pleading can be struck out by the court in any of the following circumstances. One is where the pleading discloses no reasonable cause of action. So where a pleading discloses an action that is not reasonable, cause of action that is not reasonable, maybe the basis upon which you're bringing this particular action before the court is not reasonable, then the court can strike out that pleading that you have filed. Also, where that particular pleading is frivolous and vexatious, where the pleading does not hold any water, where the pleading in itself, it is a type of pleading that no reasonable court will want to entertain it. So it will be said to be in itself frivolous. So the court cannot entertain it. In other words, the court will strike out that pleading. So it will not even go to trial. Remember, we are treating pre-trial proceedings. So these are the things that happen even before the actual matter goes to trial. So the court can strike it out at this stage. Also, where such a pleading may embarrass or delay the fair trial of the action, then the court can also strike it out. Also, where the pleading is otherwise an abuse of court processes, then the court can also strike it out. That is what we are talking about here. Now, what about consolidation? What about consolidation of action? When we talk about consolidation of action, this is the process whereby two or more actions pending before a court but within the same jurisdiction are by order of the court joined and tried together at the same time. So what we are talking about here now is that, for instance, I know that most of us have gone to court. You will see, you can come to the court, you will see court 1, you will see high court 2, you will see high court 3, you will see high court 4. The implication now, probably now you have a matter in high court 1, you have a matter in high court 2, you have a matter in high court 4. All of them are in the same jurisdiction of probably Anambra State High Court, but they are before different judges. Now you can make an application. You can make an application to the chief judge for your matter to be consolidated. Consolidation means let us bring all this matter before one judge so that it can be dealt with simultaneously. So that it can be dealt with simultaneously. Now, but what you need to note is that despite the matter has been consolidated before one judge and one judge is now handling those different matters, the implication is that when the judge is about to give judgment, the judgment is going to be on the separate matter. So meaning the judgment of the court is not going to be one judgment on all of the matters. No. So it's going to be separate judgment to be given for those different consolidated matters. That is the implication. And remember that application for consolidation is made to the chief judge. The reason for this is because you cannot make application to the judge of High Court 1. The judge of High Court 1 does not have the power of sending the matter before him to another judge. So it is the chief judge that can say, okay, let these matters be consolidated. Okay, Judge A now handle all the matters since there are the matters that fall within the jurisdiction of the High Court. It's just that unfortunately they are before different judges. Now I want you to differentiate this between when the matter are in different courts. This is the same court. We call it the same court. It's just that It is the same court because it is high court, but when a different court, probably now a matter that is in the federal high court cannot be consolidated with a matter that is in the state high court, and also a matter that is in Anambra, taking place in Anambra State, cannot be consolidated with a matter that is taking place in Kano State. So consolidation has to deal with a matter that is before the same court but different judges. Why I'm using the word the same court, don't misconstrue it that the same court could mean that high court one. We just say different judges, but remember now that those judges are judges of the same court, that is the same high court of Kano State or the same high court of Kaduna State, but different judges. That is where you get high court 1, high court 2, high court 3, high court 4. So the matters can be consolidated for the ease of determination and also for the purpose of convenience. Now, what about an instance whereby the matters that were consolidated ought not to have been consolidated in the first place? Whereby they ought not to have been consolidated in the first, so meaning that wrong matters have thus been what? Consolidated. What would the court do? Now, this time now, it is going to be the judge before whom the matter has been consolidated. He can choose to deconsolidate the matter. So he can choose to separate the matters so that all of them can be separately dealt with, because in his view those matters ought not to have been consolidated in the first place. Those matters ought not to have been consolidated in the first place. Now, with respect to the issue of consolidation, it is either of the parties that can apply. Assuming I have a matter with you on a separate subject matter in High Court 1, I have a matter with you again on a separate subject matter in High Court 2. I have a matter with you again on a separate subject matter in High Court 3. Now, any of us can apply, let these matters be consolidated before one judge. But when it is with respect to deconsolidation, either of the parties can apply to that particular judge that is now handling the consolidated matter to deconsolidate it, or the court so much that is on its own volition can really look at it and say that this matter ought not to have been consolidated in the first place, and the court can deconsolidate it. But one thing about consolidation is that the person that authorizes it is the chief judge, but in deconsolidation the person that authorizes it or that does it is the judge before whom the matters have been consolidated. That is one thing you need to take there. Now, what about settlement of issues? When we talk about settlement of issues, it is with respect to when parties have come together and they have decided to outline the material facts that is really the problem between them. For instance, now, if somebody has said in his statement of claim that this young man is owing me 500,000 naira, and the young man in his statement of defense says, I have already given him 250,000 naira, meaning that what I'm owing him now is what? 250,000, no longer 500,000. Now, the claimant now, because this is a new issue that has been raised, and you know that when new issues are raised, the claimant is still entitled to file another pleading called reply. So maybe the claimant in his reply now said, yes, he really gave me 250,000 naira. So meaning that he's owing me 250,000, no longer 500,000. Now, if you notice now, what was contained in the statement of claim was 500,000. But now in his reply, now he has admitted to have been given 250,000. So that means that what the court is determining now is the issue of 250,000 and not the issue of 500,000. So the parties can come together now and agree that what is the subject matter now that we are now looking at how to resolve is 250,000, no longer 500,000 naira. That is what is called settlement of issues. When the parties agree among themselves as to the type of as to what they are going to try, as to the issues that they will be taking to trial. Now, one thing about settlement of issues is that the parties can agree and settle issues, or the court can do that for him. Now, I don't want you to see settlement of issues as that the parties have settled out of court. No, settlement of issues means that they have maybe outlined, they have pinpointed the type of issues that are necessary to go to trial. That is called settlement of issues. So don't take settlement of issues as to mean that the parties have settled. No, it only means that the parties have decided to isolate the material issues that need to go to court, not necessarily coming to court and wasting the time of the court. So just bring to the court what the court would ordinarily look into and determine for you guys. That is why our topic is pre-trial proceeding. Pre-trial means these are the things that we need to do before the matter would go to trial. Now, what about discovery of facts and documents? What about discovery of facts and documents? For instance, now, if there are some documents that are probably within the within the disposal of either of the parties, maybe the defendant is with a particular document, then you, the claimant, really want the defendant to either present the document during trial, or you want the defendant to give you the document. Then you can actually maybe give him a notice of discovery. You can actually give him a notice of discovery. Now, when you really want him to disclose some certain facts, you can actually raise some questions and give to him to answer. And that particular document to raise the question is called interrogatories. It is called interrogatories, where you are requiring the other party to disclose some certain facts. Then you can actually give him a document called interrogatories. Now, that document called interrogatories that you've given to him, if he is now giving you reply, that is if he's now answering to the question that you have raised, it is called answers to interrogatory. The document he will be filing to you, or it will be filing to you, is called answers to interrogatory, and it is always by way of an affidavit. So meaning that he is going to swear to an oath that what he is telling you or the answers he's giving you are correct. So that is why it is always by an affidavit. So answers to interrogatories are always by way of affidavit. They are always by way of an affidavit. Now, what about notice to admit? The issue of notice to admit has to do with, you can actually, maybe after you people have filed pleadings, you can actually communicate the other party, maybe the defendant, asking him to admit by way of motion ex parte, seeking to obtain the leave of the court to call on the other party to admit certain documents or facts. Now, where the court grants you that leave, it shall fix the terms and conditions of such admission, including the time within which the admission ought to be made. And now the party who is served may file a notice of non-admission. Where he does not file such notice, he is taken to have admitted the documents. So what we're talking about now is, for instance, now we have already filed our pleadings. I could now, by the leave of the court, tell the court that I want this particular young man to admit that he is actually owing me so amount of money. Now, when such has been filed, if the young man actually does not want to admit that particular fact, he is expected to file notice of non-admission. But if he just keeps quiet and he didn't file the notice of non-admission, the implication would be that he has admitted to those particular things that you have contained. Now, therefore, that other party may apply for judgment based on the admission. And the other party has only 4 days to file either a notice of admission or non-admission. And when he files a notice of non-admission and at trial, it is proved against him, then he would bear the cost of proving the documents or the facts denied. So the implication of this is that, assuming he ought to have admitted and he refuses to admit, then the implication now is that when the matter goes to full trial and the facts are proved against him, then he will bear cost for proving such particular facts against him. Now, what about case management conference? When we talk about case management conference, this is a semi-formal arrangement where neither the judge nor the parties are robed. So in this arrangement, neither the judge nor the parties are robed, and it is to be held day to day, and it lasts for about 3 months, and it can be extended upon the application to the chief judge. So it is in case management conference now that the parties are expected to come for the case management conference judge. The CMC judge is most often than not different from the trial judge. So for the case management conference judge to determine the matter between the parties, in Abuja it is called pre-trial conference, while in Lagos it is called case management conference. Now the summary procedure for case management conference are as follows. The claimant is to apply for it by filing Form 17, known as CMC notice, within 14 days of the close of pleadings. Within 14 days of the close of pleadings, he is expected to file. Now, the court registrar will issue and serve him Form 18, known as CMC information sheet. So when he has already filed the application in CMC Form 17, the registrar of the court will now issue him Form 18, known as CMC information sheet. And when it is issued to him now, the judge is to issue a scheduling order after the defendant had returned Form 18. Please, the defendant will now be given that Form 18, letting him know that there was a CMC notice in Form 17. Now, the judge will now issue what is called scheduling order after the defendant had returned the Form 18, which was the CMC information sheet, maybe where he is now declaring his intent to submit to the jurisdiction of the court with respect to the case management conference. Now, all pre-trial applications are dealt with at the CMC. And at the end of the case management conference, the case management judge is to issue a report which shall guide the subsequent course of proceeding by the judge to handle the trial. So the judge to handle the trial is most often than not the case management conference judge. So it is worthy of being noted. And it is worthy to note also that if the claimant fails to apply for the CMC notice, the defendant may make the application for an order dismissing the action. So in this instance now, it is behooving on the claimant to make application for a case management conference to be held by way of CMC, that is case management conference notice. And the pre-trial judge is usually different from the trial judge, like I've told you. And if the claimant fails to attend CMC, his action will be dismissed. But where the defendant fails to attend, default judgment will be entered against him. If you listen to my voice note on summary and default judgment, you will appreciate when I say that we have default judgment, we have judgment in default of appearance and we have judgment in default of pleadings. So where the defendant fails to appear, then judgment will be given against him in default of appearance. Now, where a case is suitable for ADR, the pre-trial judge shall direct the case to an ADR judge. So where a case is suitable for alternative dispute resolution, I believe you have heard about multi-door courthouse in Lagos, in Kano, even in Abuja. So now, the implication now is that during the pre-trial conference or case management conference, the case CMC judge will now look at the matter and know whether this is suitable for alternative dispute resolution. If it is, then it will be directed to the ADR judge. Now, what about withdrawal or discontinuance of pleadings of action? For instance, now the parties might have been done filing their pleadings, although, because you remember we said that what we are discussing are the steps that take place after pleadings have been filed, after close of pleadings. So maybe after this now, maybe the parties might have resolved among themselves, even after filing pleadings, but before the date fixed for hearing, they might have resolved. So they can maybe conclusively make an application to withdraw that particular suit that has thus been filed. So, and that's, in other words, we bring it to an end. That, in other words, we bring it to an end. That is discontinuance of action. I hope you know that if it's civil, that the parties are among themselves going to agree whatever thing they want. But if it is criminal, then unavoidably there is a consent of the Attorney General before you can withdraw, because the matter is between the accused and the state and not between you and the accused. Even if you are raped, you are a witness for the purpose of that particular matter. You are not a party. So that is why if you go at the back and agree with the accused and settle without communicating or without getting the consent of the AGF, such is called compounding of offense, and it is a crime in itself. So that's what we are saying now, that the parties in civil, they are at liberty to agree and decide to apply to the court to withdraw the matter that have been filed or the pleadings that have been filed, and the court will very, very happily grant them that, because the court is always enjoined to advise the parties to engage in amicable settlement of the matter. So whenever parties apply for withdrawal and to discontinue the action, the court most often than not does not tell them no, because it is civil in nature. Now on that, we're going to be drawing the curtain on the topic. And remember, what we have thus discussed are actually revolving around law school outcomes and law school expectations. And maybe when you finally pick a book to read, most of these things now can probably take 2, 3, 4, 5 pages. So just don't worry yourself, pick the main points and appreciate it for the purpose of your bar finals, assuming you see it in the examination. And please, that particular answers to interrogatory, note that it always comes by way of an affidavit. And until I meet you again, do take good care of yourselves and have a very blissful night rest.